What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. So, I don't know if you guys have been following it, but there's this case in Kentucky where the sheriff, Sean Steins of Letcher County, Kentucky, has pretty clearly shot and killed a district court judge named Kevin Mullins, and he did it in the judge's chambers. Well, today they had and aired the preliminary hearing for the case, and I thought it might be fun to do something a little bit different than what we normally do and just kind of watch it together and talk about some of the things that take place in a preliminary hearing and what the state is actually trying to prove in the process. The reason I decided to do this is because I was looking through the comments that people were making on the actual news channel's feed, and it became pretty clear to me that people really just don't understand how the law works, what the purpose of a preliminary hearing is, or anything about that. So I thought what we'd do is just kind of walk through. It'll be kind of a long video, so I apologize to you in advance. I will tell you up front, it turns out that this was being recorded by surveillance video, and I'm not sure whether the sheriff knew that or not, but I will not be showing the actual shooting because I don't want to get an age restriction on YouTube and keep people from being able to see the video. But I will link the video in the description that has the actual shooting where you can see it. Now, they do blur it out on the news channel, but you can still see the shooting. So with that, let's get into it and let's start watching the preliminary hearing.
Morgan District Court is now in session with the Honorable Rupert Bilhoy.
Thank you, sir. You may be seated. I'm going to call the case of Commonwealth versus Sean Steins, 24F 147, on for preliminary hearing. Is the Commonwealth ready?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right, call your first witness.
Commonwealth's Clayton Stamper.
All right, click. Mr. Stamper, if you would. Raise your right hand for me. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You may be seated.
You state your name for record, please.
Clayton Stamper,
And how you spell your name, Mr. Stamper?
ClaytonStamper.
Tell the court how you're employed.
I'm sorry.
How are you employed?
I'm a detective with the Kentucky State Police assigned to Post 13 Hazard.
How long have you been employed in that capacity?
I've been with KSP a little over 24 years, detective since 2006.
And have you, in the performance of your duties as detective with the State Police, have you investigated the death of Kevin Mullins?
Yes, sir, I did.
And can you tell us on what date that was?
It was September 19th, 2024.
In investigation of that death, were you able to determine who killed Kevin Mullins?
Yes.
And how were you able to do that?
Video surveillance footage.
And did you retrieve that video surveillance footage?
I did.
Okay, so I've been following this case for a little bit, and I didn't know until I watched the video this morning that there was surveillance video. They've been really tight-lipped. They don't want, and we'll find out, this thing is starting to unfold like an actual John Grisham novel. So we're going to find out, there's going to be some bombshells that come along in this case, and some facts that come out that are going to really shape the way that the public sees this case. And I do have the benefit of having watched this video earlier, and it's the reason I decided to do a video on it. But they're basically laying the foundation. They're trying to get who he is, what his basis is for testifying. In a minute, you'll hear them ask about where it happened. They're trying to set, that's called venue. When you're establishing probable cause, one of the things that you have to establish is that it happened in a place where the court overseeing the case has jurisdiction. And so anytime you're watching a preliminary hearing or a trial or something like that, and they say, and where did this occur? They want to make sure it's called establishing venue. And if you do not do it, it is a basis to have the case dismissed by the defense. So if they went through all this stuff and they never established it at preliminary hearing and they never established it at trial, it is a legitimate motion for a defense attorney to move for a dismissal based on the fact that they didn't prove venue. So that's when they ask where it happened, that's what they're trying to do.
You know, at this time, the Commonwealth moved to play video footage.
Yes, approach the bench.
So obviously the defense lawyer is trying to object. Now, you have to understand that there's some legal maneuvering going on in a preliminary hearing. Even though it might sound ridiculous that the defense lawyer wants to object, you have to preserve errors along the way for the record on appeal. So if something happens, like certain things will or will not be allowed into the case, into the evidence of the case, based on whether or not they are overly prejudicial against the defendant. And so the defense attorney, even though he knows he's going to lose, and even though he knows that it's almost disingenuous to object to the only independent witness to this crime, the video surveillance being played, he still has to do that to preserve the record, so that if for some reason this guy loses at trial and he files an ineffective assistance of counsel claim against this attorney, he'll be able to say, well, no, for the record, I objected to this, I objected to that, I lost those rulings. If you make your objections, you put it before the judge, it's off of you. It's on the judge then. It's not on you anymore. But if you don't make those objections, then you're being ineffective as a lawyer. So eventually he's going to lose this objection and they're going to play the surveillance video again. I will show you important parts of it, but not the actual shooting itself.
You ready to proceed?
Come straight, Your Honor.
All right, go ahead.
Okay, we're going to make a couple notes here, and I'll come back and talk about why they're relevant, because I want you to see the defense attorney's cross before we talk about why they're relevant. People have some ideas in the comments as to why the defense attorney's doing what he's doing. They're wrong, and I'll explain what he's trying to do and what he's trying to establish. But first of all, you see that the sheriff is standing in the corner, and he's already drawn his weapon and he's pointed it at the judge. We'll say this happens in 3 phases, okay? And you'll understand in a little bit. So the first phase is as far as the shooting itself, the sheriff stands up, he points the gun, and he fires multiple rounds at the judge. The judge falls over in the corner. That's phase 1. Phase 2, the sheriff moves around to the other side of the table so as to be able to get a better aim on the judge. The judge is clearly still alive. You see a blur moving around as he's sort of tussling about trying to get away and defend himself. The sheriff aims and is not pleased with that shot, then gets closer, points over the desk, and fires what I assume to be a intentional headshot or an attempted intentional headshot at the judge from a position standing over his position on the floor. Phase 3, the sheriff starts to leave, stops at the door, ducks down under the table, and appears, at least to me, to fire maybe 2 more rounds at the judge. That will matter, and I'll explain why, but let's move on.
And were you able to identify the parties we saw in that video?
That was Sheriff Mickey Steins and Judge Kevin Mullins,
And also, who had the firearm?
Sheriff Steins.
And then, Judge was also in his black robe.
Yes.
Do you know what portion of the courthouse that is?
That is the judge's chambers
And where's that located at, physically located?
in the Letcher County Courthouse.
That's all I have, Your Honor.
Okay, again, you just heard him say, do you know what portion, where that's located? Okay, it's located in the courthouse, establishing the venue for this act. And then he also asked to identify the defendant. What he should have said is, do you see the person that was in the video in the courtroom today? Because identification of the defendant is another thing that is required for probable cause. So I think it's pretty obvious and accepted that everybody knows who the elected sheriff is. So probably not like reversible error or anything major here. But normally what you want to do is you want to say, do you recognize the person in the video? And do you see that person in the courtroom today? And can you point to him and describe what he's wearing? That's an identification of the defendant for the purposes of the record and for the purposes of probable cause. And what he should have done also, I'm not sure if he didn't do it, but he should have asked the officer, how are you familiar with this video? This is called authentication. How are you familiar with the video? Okay, and then after the officer explains, well, I received the video from the surveillance or whatever, so you lay the sort of chain of custody and the foundation of it, and then you authenticate it by saying, is that a true and accurate depiction of the way you remember things on that day or whatever it is? Now, if this detective, you'll find out, doesn't have personal knowledge of everything he's going to talk about, which is somewhat extraordinary. Normally, a witness is not allowed to testify to things they don't actually have personal knowledge about. But I think this is going to be acceptable because of the notoriety and sort of it's understood what happened here. But let's move on.
Would you like to cross-examine the witness?
I would, Your Honor. That was a short clip that was played there. How long do you believe that clip was?
That we just watched,
Yes, sir.
just 10 seconds, 15 seconds.
10 or 15 seconds. In fact, the video that was taken in the judge's chambers between the meeting between Sheriff Steins and Judge Mullins, it's my understanding that video lasted much longer, correct?
Yes,
Okay. And have you had an opportunity to review the video
I have.
of the prior incident?
I have.
And can you describe for us what happened immediately prior to the clip that we saw?
Sheriff Steins uses his telephone to make some phone calls. He then borrows Judge Mullins' cell phone and appears to make a call on that. And that led to what you just saw.
Okay. So it's my understanding there were some people who were having a meeting with Judge Mullins prior to the sheriff's entry into the chambers. Is that correct?
Yes.
Have you identified those witnesses?
I don't know the names of them. There's about approximately 4 people in there. Then Sheriff Steins enters the judge's chambers and everybody else clears out.
You don't know their names?
Not right off, no.
Have you prepared a report? that
In
might,
the process, yes.
you're in the process of preparing a report,
Yes, a lot of information.
but you've not spoken to any of those witnesses?
I've not directly, but they've all been interviewed. There's recorded interviews of those people in the case.
Okay, so other officers have spoken with those 4 witnesses?
Yes.
And what is your understanding of what those 4 witnesses have said?
I don't recall.
You have no idea what they said?
No.
Okay, this was a mistake. One, the prosecutor should have objected to the question. So the way that probable cause works for a preliminary hearing is a state gets to choose what evidence they bring forward for probable cause for the purposes of probable cause. And probable cause in a preliminary hearing is basically this. A crime was committed, it happened within this jurisdiction, and we believe that it's more probable than not that this defendant committed the crime. Okay? That's all you do to establish probable cause. Then what happens is the judge binds the case over and it gets presented to the grand jury. They take the information and they issue an indictment. And the reason the indictment matters is because you're not actually formally charged until the indictment. Even though a judge may find probable cause, when the case is presented to a grand jury, the grand jury could still opt to no true bill that case or opt not to indict it, and then the case ends. And so before you can even proceed to trial, you must have an indictment. Now, this was a mistake because the prosecutor should have objected and said, Judge, this witness does not have personal knowledge of the actual interviews, and that is not part of the state's case for probable cause, so it's beyond the scope of what the state has offered. You're supposed to be able to ask, and it depends on the state. Some states have open cross, some states have cross that's based on the scope of the evidence presented by the state. I'm not sure what Kentucky has, but generally you would try to object and try to keep it to what the state has actually proffered as evidence for the purposes of probable cause. And the reason that this is going to come back to bite him is because the detective just pretty much lied. The detective just sat there and said that he had no idea what these witnesses said. And that's just flat out not true. In fact, we're going to find out in a few minutes that he's going to start saying what he heard that they said. And so you already have an impeachable statement there because he's already stated under oath over here that he has no idea. The lawyer said, so you have no idea what they said. And he said no. Now, it doesn't help the lawyer in any way with this case to start a feud with law enforcement. And I'll get into that somewhat in the strategy part of it, but it doesn't help him. They need the jury to like and sympathize with his client because The whodunit is not really in question here. It's the motive that will either put him in prison for life or set him free. So it doesn't necessarily benefit the lawyer in any way to attack the witness at this point, but this was a mistake by the prosecutor for not objecting, and it was a mistake by the state's witness because he puts his own knowledge of the case in question. And actually, he kind of compromised his own credibility because everybody knows that he knows what the people said. Anybody that they would bring on the stand as their primary witness for a preliminary hearing would have to have a good idea of the totality of what the investigation has brought forth. And this is not your typical murder case. This is an elected sheriff killing another elected official for some pretty scandalous stuff, as we're getting ready to find out. It's not like this guy has thought about anything else for the past few weeks when he's been working on this. So the idea that he doesn't know is just flat out a lie, and it's disingenuous, and everybody knows it. Let's move on.
I want to make sure I understand, had there been a hearing previously this day in chambers?
In the courtroom?
No, in chambers.
Not that I'm aware of.
Okay. And so there's a video camera that is running in the district judge's chambers. Is that on all the time?
It's my understanding, yes.
And have you spoken with anyone about why that may be?
No. I mean, there's cameras throughout the courthouse.
Well, fair enough, but are you familiar with district judges' chambers normally, how they're set up?
No. I mean, some of them have video surveillance and some don't.
Right, but
This one does.
generally when they have surveillance, you agree with me that that is utilized when there is a proceeding going on in chambers, correct?
It could be, yes.
Okay. And I'm just asking, so this video didn't have an audio recording to it,
No,
correct?
there's no audio.
Outside of once the four people that were inside, that we don't know their names, once these four people had left the chambers, were they in an area adjacent where they could hear anything that was going on?
Yes, I believe some of them did remain in the next room.
What did they tell us?
Do what?
What did they hear?
I've not been part, I wasn't part of those interviews.
Okay, so if I'm understanding correctly, you're prepared for a preliminary hearing on a murder, and there are witnesses in an adjacent room.
I mean, they heard
Can I put
gunshots.
my question, please?
Yeah, let him ask the question.
Thank you, officer. So you are investigating a murder and testifying in a preliminary hearing, and there are witnesses who may have overheard what preceded this edited clip, yet you can't tell us today anything that they said?
I've not personally listened to those interviews. I've talked to the other officers that did those interviews.
Fair enough, and I mean, we're here at a preliminary hearing, as you know, that you can testify to hearsay. I'm asking you what they said.
They heard gunshots.
Okay, was there any statements that they overheard?
No.
Were there raised voices?
There, one person stated that she didn't recognize him as being Judge Mullins' voice, but heard somebody say, "Help, help."
Okay, so this part was a good job by the defense attorney because he's already using the detective's former statements to impeach his current testimony. Again, he just 30 seconds ago told us that he had no idea what was said. And now the defense attorney is pulling it out of him, and it is like pulling teeth, but he's pulling out of him what he does actually know. And now he's saying, well, they heard him say that they didn't recognize it as the judge, but they heard somebody say, "Help, help." So again, we're seeing that the detective was sandbagging his actual knowledge. And again, this is part of the problem. The prosecutor should have been more thorough in his preparation of the witness and helped him stay on course as to what they were going to offer for the purposes of probable cause. So he's gotten worked into a little bit of a trap here because of his own silliness and trying to be less than forthcoming about the facts that he does understand. And the defense attorney's doing a pretty decent job here of showing that.
Presumably that will be after the firearm was drawn or shot.
Objection, Your Honor.
I withdraw, Judge.
Withdrawn.
So Is there any testimony that you can give us today about any statements or arguments or the content of that argument prior to the shooting?
No.
Okay. I want to ask generally, so did you process the scene? Are you the lead investigator on this case?
I am.
Okay, so as a lead investigator, I would presume that you would have secured the chambers and evidence once you arrived.
I was part of that, yes.
You were part of it, right? But you're the lead investigator, so you'd be in charge of those duties and delegating what should be done. Is that
No.
fair?
No, I don't delegate what's done.
Okay, so you're the lead investigator. What does that mean?
I'm the case officer.
So the state's witness is not doing a great job here because he's making it obvious that he doesn't understand incident command, or that his job as the lead investigator is to actually control what happens inside his crime scene. That's how you maintain the integrity of the evidence. That's how you stand before a jury, stand before a judge, pass all the technical tests about the integrity of the evidence and all that stuff by saying, yes, I was the person. I was the point of contact. I was the person that controlled the scene. I controlled the people who came into the scene. I took names of the people who came in and out. I made sure that the scene wasn't tainted. I made sure that A, B, C, or D happened. You're the lead investigator. You're the person they're putting on the stand. You're the star witness. How do you sit there and say that you don't delegate things? If you are the lead investigator and it's your case and you're not delegating anything, then who's in control? Who's leading? Who is making sure that things are done correctly? When you get a bunch of different human beings working together, all doing their own thing autonomously and independently, things go bad, and that's how you end up losing cases on evidence technicalities because nobody knows who's in charge. So maybe he didn't understand the question or something. I don't really know, but he's not doing a great job of showing his competence in the way that the scene was investigated.
Okay, so you're carrying the case. So I want to make sure I understand. Had Judge Mullins been removed from chambers when you arrived?
No,
Were you able to ascertain, did he have a firearm on his person?
we did not locate one.
You did not locate one?
No, there was not one in the chambers.
Okay. And there was none on his person?
No.
So two different answers right there. Did he have a firearm on his person? We did not locate one. The lawyer picked up on it right away. You didn't locate one? No, there was not one in the chambers. Those are two different things. We believe that was a gun, but we didn't find it, is one. Or we didn't look for a gun, so we didn't find it, is another. And then on his person is different than in his chambers. But again, this detective, 25 years at the Kentucky State Police, and I'm not impressed.
Okay. All right. Who was the first person to arrive on behalf of law enforcement to investigate?
They were already in the courthouse.
Fair enough, but I'm talking about in terms of people that we may see a report from or take part in this investigation. Who would be the first person?
I believe Trooper Jason Bates was the first KSP personnel on scene.
Okay. And you spoke with him, and
I did.
he searched and did not locate a firearm?
No, he didn't search the scene, no.
You
His
just-
role,
Sure.
his role at that point was security of the scene.
Okay, now this is an interesting idea, right? So he just says that Trooper Jason Bateman from the Kentucky State Police his primary task was security of the scene. But he also, just prior to that statement, said, no, he didn't search the scene. I can promise you 1,000% that if they came to your house today to execute a search warrant or to look for a wanted person because they had an arrest warrant, they would sweep your entire house as part of securing the scene, and in the process of that, they'd be searching for weapons, okay? The idea that you go to a shooting call and you are tasked with securing the scene, and that does not include a search for weapons, is insane. I'm at a loss for words on this witness here.
I understand, but I'm just trying to ascertain. You said earlier that there was no firearm found.
No.
I'm wanting to know, can you tell us, was it specifically searched for a firearm?
In the judge's chambers,
Yes, sir.
There was myself, Detective Chris Collins, Detective Scott Caudill, Detective Eric Caldwell. That's all I recall right now.
Okay, but I'm trying to understand, so who searched specifically for a firearm?
We all did.
And that was specifically something you looked for?
Yes.
Fair enough, okay. Of course, your investigation, did you ascertain that prior in the day, there had been a lunch meeting between Sheriff Steins and Judge Mullins?
There was.
Pardon?
There was.
Okay. Sorry, I couldn't hear your response. I wasn't being trite.
So you'll notice there that the defense attorney apologized to the officer. Somebody coughed in the gallery, and he didn't hear his response, and so it almost sounded like the defense lawyer was being a bit of a smart aleck with him. He's kind of handling the cop with kid gloves, and there's a reason for that. And I'll explain more of that in the closing when I talk about strategy and how it doesn't help him to be combative with the police right now. His client is guilty of killing the judge. There's no question about that. But there's still potential that his client will not be convicted of this crime, and I'll explain more of that in a little bit. So it does not help him in any way to lose rapport with any of the witnesses at this point.
So where did this take place?
It's a restaurant called Street Side, and it's just down the street from the courthouse.
Okay. And it's my understanding there were a couple of other people who attended the luncheon?
There were several, yes.
Okay. And at some point after that, they wrapped up lunch and left, obviously, and went back to the courthouse. Are you aware of anything so far in your investigation that would tell us there was any issues at lunch between Judge
No,
Mullins and Sheriff Steins?
no.
Okay. But someone on behalf of the KSB has spoken to those witnesses?
Yes, they've all been interviewed.
And there was nothing unusual that had arisen during that luncheon?
I was told that the judge made a statement to Mickey about, do we need to meet private in my chambers? That's all I was told.
Do you know the context of
I do
what
not.
the conversation was before that they would need to discuss in chambers?
I do not.
So it's my understanding that in the larger portion of the video that we haven't had access to, that there is a point when Sheriff Steins asked for to see the telephone of Judge Mullins.
Yes.
Is that a yes?
Yes.
Yes, okay. And I would presume that you and the other officers you mentioned, when you secured the scene, that you secured those phones as well. Is that correct?
Yes.
And have you reviewed both of those phones?
They're currently at the forensic lab at this time being downloaded. I have had discussions with the people at the lab regarding the downloads.
And those are a couple of other questions that I was going to ask you, but my original question was, have you reviewed or are you aware of the content of the phones?
I've not personally seen it because I've not received those reports yet.
Okay, again, based upon your conversations with the officers, are you aware of any recent content that was up and could have been relevant at the time of their discussion?
I was told that Sheriff Steins had tried to call his daughter, and he had tried to call his daughter from the judge's phone also.
So, have you obtained the phone records from Judge Mullins' phone?
I don't have those in my possession yet, no.
Okay, have you issued a search
Yeah,
warrant for them?
yes.
Okay. And have officers confirmed that the sheriff's daughter's phone number was on Judge Mullins' phone?
Yes, I
Okay.
believe so, yes.
So that number had been called from Judge Mullins' phone?
Yes.
Is that correct?
Yes.
Okay, so now it's starting to get interesting. So apparently the sheriff, the girl in question here, from all the reports I can find, is either 16 or 17 years old. So she's certainly underage. So apparently the sheriff tried to call his daughter from his phone. She doesn't answer. He asks the judge to try his phone, uses the judge's phone to call his daughter, and his daughter answers. And then right after that is when the shooting happened. So it's starting to get a little bit interesting here. And you can use your imagination as to what sort of form this case is starting to take.
So we don't have a viewing of what transpired during that exchange of phones. But based upon your review of those moments prior to, when Sheriff Steins observes that cell phone, was he previously seated?
Yes.
Okay, so in the clip we saw, he was standing the entire time.
He was seated in front of the judge's desk.
And he looks at the cell phone. Can you describe his reaction in the video that we haven't seen?
Whose reaction?
Well, the sheriff.
You can't see his face in the video.
Okay. But is it clear that, does it appear to you that, let me rephrase this. Did he stand up after
Yes.
looking at the phone?
He stood up.
And how long after he looked at the cell phone and stood up did this occur that you played?
Just seconds.
Okay, so the very important question that the attorney just asked, and a lot of people misunderstand what he's trying to do here. Again, I've said this multiple times now, but it's important that you understand. The whodunit is not in question here. What will ultimately happen is this attorney's job is to keep his guy off death row or out of prison for life, or possibly get an acquittal based on what else we learn. But the point is, they've charged him with premeditated murder or murder with malice aforethought. Different states, commonwealths phrase it different ways, but it's basically first-degree murder. It's premeditated murder. And so what he's trying to do is establish, based on the opinion of the lead investigator, who's identified himself as the lead investigator, whether or not this is a heat-of-the-moment type thing. And he's not trying to say that the sheriff didn't kill the judge. What he's trying to do is lay the foundation for what will ultimately be a challenge to the premeditation part of this case. Now, they're going to have some problems based on the video, and I'll talk about that more in a little bit. But this lawyer's doing a pretty good job of establishing the fact that even the lead investigator has a hard time proving premeditation here, because he's trying to get the lead investigator to acknowledge that everything was kosher until he saw the phone, and then he had an emotional reaction, which is a heat-of-the-moment type, it excludes malice aforethought. It excludes premeditation generally. But again, we'll talk about that. There's a little bit of nuance there. But that's what he's trying to do. He's not trying to do anything other than establish that this wasn't premeditated, that he acted in the heat of the moment and overreacted to the stimulus of hearing his daughter answer the phone for a judge, but not him.
Did you make the decision on edits today for what you were going to present?
Do
In terms of, did you make the edit or determine
No,
which portion of the video we were going to see today?
No, sir, I did not.
Both cell phones have been sent to the Kentucky State Police Forensic
Yes.
Team, is that correct?
Yes.
Have you gotten any early report on what was found?
No.
Were both phones still on the desk when you arrived?
The judge's phone was on the desk. Sheriff Stein's phone was on his person.
Okay, so are there photographs of, was the phone locked at that point, or was it still open?
Both of you asking about both of them, or?
First let's talk about, that's fair. First, I'm talking about Judge Mullins, since it was the one that was still on the desk and presumably, nobody touched it prior to you securing it, correct?
No.
So, yeah, so would like to know about that. Have you ascertained what was currently open on that cell phone?
No, I don't know at this point, no.
You don't know.
No.
Do you think that would be Do you think that will be important to learn?
I hope to learn that when the report's ready, yes.
But as of today, you can't tell us
No.
what was currently open on the judge's phone.
No, sir.
Did you conduct an interview with Sheriff Stein's daughter?
I did not, but she has been interviewed.
Are you aware of who was present when she was interviewed?
Lieutenant Randy Combs and Detective Anthony Trotter.
And she was interviewed with or without her parent?
With.
So her parent was present at the time you interviewed her?
Yes, I believe. I wasn't there, but yes, I think so.
And law enforcement has not spoken to her without her parent present?
Not that I'm aware of.
Okay, so that is establishing that she's underage, because obviously that question wouldn't even come into play if she was of the majority age. So she's got to be under 18 or he wouldn't have asked that question. So again, I don't know how old she is. The reports I've been able to find are 16 or 17 years old, but he's trying to figure out whether or not the law enforcement officers inappropriately talked to a juvenile without their parents present or interviewed a juvenile without their parents present. So again, I think that pretty firmly establishes that we're talking about a relationship between an underage girl who happens to be the daughter of the sheriff and the judge that was ultimately killed.
Did the Kentucky State Police obtain her phone?
No.
You intend to obtain records for her cell phone number?
Possibly, yes.
Do you believe that that will be soon that you'll do that?
Could be, yes.
Had you already intended to do that, or did you just respond to my question?
Well, the call should be on the judge's records too.
Well, I understand.
And
but-
she's made statements about what occurred during those conversations.
See, that right there was really good by the lawyer. He basically called him out. You can tell that these guys think this is an open and shut case, and they probably had no intention of subpoenaing the phone records or confiscating the phone of Sheriff Stein's daughter. And in the process of him asking, he just basically said, did you actually intend to do that before, or did you just say that in response to my question? And it almost like, has it just occurred to you, Mr. Lead Investigator, that it might be relevant to actually get the phone records for one of the people who's actually involved in this pretty substantially, right? So to me, this shows a layer of incompetence on the part of the investigative team, whoever's investigating this. Either incompetence or arrogance, like that they think that this is an open, closed case and a slam dunk, and that they don't need to. Now, there are going to be people who say, well, there's a cover-up going to happen or whatever, and there are going to be people who are out there who are saying, well, they don't want to get her information off her phone because there's a cover-up. And I don't have energy for that stuff. What I think if I can mark something up to incompetence instead of malevolence, I generally try to do that. Because I think there are far more incompetent people at their jobs than there are people who are just plain out evil or have nefarious intent. But anyways.
I understand that, but I would presume that, have you ascertained whether Judge Mullins also had apps that stand outside of phone records?
I've not received those records yet. I don't know what's on the phone.
Fair enough, but did you look at the phone? Did it appear there were apps on it?
I'm not the person that's qualified to look through the phone.
Okay, but you're familiar with cell phones. They can host other forms of communication. Yes, sir.
What's the objection?
He's been asked an answer, Your Honor. He's asked a question, I think, about 4 or 5 different ways. The officers, the detective repeatedly said that he does not have a report with phones, he's not looked at the phone, he can't testify to that matter.
I'll let him ask the question, and he can only testify what he has personal knowledge about.
Absolutely, yes, sir. Thank you.
Right.
So you're aware that phones can be used for apps such as Facebook?
Yes.
Okay. And that is not something that is captured by cell phone records. You would agree with me?
I agree.
Okay. So in light of that, although the records may be mutually the same between Judge Mullins' phone and the sheriff's daughter, Do you believe that you could also ascertain other information from the cell phone app content?
Are you asking what apps are on the phone?
Yes. Well, that was my original question.
I don't know
thought you would
without, I've not received that report yet. I don't know what apps he had downloaded on the phone.
If he has social media apps, do you intend to?
That could lead to additional search warrants, yes.
If you would, officer, please let me finish before you move forward, and I'll try to slow down a little bit as well, okay?
Sure.
Take your turn. Have you determined whether there were any previous issues, personal or professional, between Sheriff Steins and Judge Mullins?
I've heard things.
What have you heard?
Just that of this regarding the lawsuit that the Letcher County Sheriff's Office is currently involved with.
Okay. The lawsuit that involved ultimately a criminal conviction of a deputy for sexual behavior in the judge's chambers, is that the one you're referring to?
Yes.
Okay, and the subject matter of that lawsuit, the chambers area, that's the same chambers in which this occurred, is that correct?
I'm not familiar with the details of that case that the lawsuit resulted from.
Okay.
So that might give us an idea of why there was actually being a recording made of the judge's chamber. So there was some theory out there that the bad blood that existed between the sheriff and the judge had something to do with this deputy that was criminally charged and fired for having sexual relations in this judge's chambers with like an inmate or somebody involved in some litigation there. And so it's possible that the reason that they were recording the chambers all the time was just to sort of so that everybody was on notice. Hey, look, anything you do in here is going to be on video. So now again, it's not clear whether Sheriff Steins remembered that when he decided to go in there and shoot the judge in his own chambers while the video was rolling, but still, nevertheless, it really, whether or not he did it was never in question here. But that may give us some idea of why it was being recorded in that particular judge's chambers at all times.
Are you aware of any criminal reports that Sheriff Steins had made of Judge Mullins prior to this day?
No.
Did you personally observe Sheriff Steins following this video?
Did I personally observe him? What?
Did you meet with him? Did you talk to him after?
He was in custody when I arrived at the courthouse that afternoon.
All right. And at some point, did you draw any observation about his demeanor?
He was mostly calm, I thought. I mean, I talked to him, but he didn't say nothing about why this had happened. But he was calm. He was kind of afraid that basically all he said was, "Treat me fair." That's basically the comments he made.
Okay. Did he also make a statement about, I didn't see it in the citation here, but somewhere along the line I saw a statement being attributed to him about protecting his family?
I wasn't present, but when he was taken into custody, I was told by one of the other officers that were there that he made the comment, "They're trying to kidnap my wife and kid."
Okay, so I think this is a mistake on the part of the defense attorney, only because of what we don't know. What we don't know. This sheriff could be abusive. He clearly has a quick temper. We don't know whether the judge was having some inappropriate relationship with this girl, or whether the judge, being a close-knit community, was involved in some way in trying to extract the wife and the daughter from some abusive relationship with this sheriff. And without knowing exactly what was said, this lawyer asked him a question that allowed him to put this statement into evidence that may or may not be damning to the sheriff, because it might prove premeditation. Because the defense lawyer thinks that that the sheriff said something about, I have to protect my family, when in actuality the testimony from the officer is that the sheriff said something about someone trying to kidnap his wife and daughter. Those are not the same thing. Nuance matters. Words matter. To say I was trying to protect my family might indicate that he's trying to protect his daughter from a child sex predator who it turns out may be the judge. But to say they're trying to kidnap my wife and daughter could be the ramblings of a person who has paranoid schizophrenia that's not been diagnosed or has just been detected but not mentioned. Or it could be that these people were trying to leave an abusive situation and he was trying to keep that from happening, and he decided to kill the judge because the judge was the only avenue of escape. So without knowing what the answer to the question was going to be, or not knowing the exact quote, the exact thing that was said, I think it was a mistake on behalf of the lawyer to ask this question in the way that he asked it, because a lot of people don't know this, but cross-examination is the one area in the courtroom where you get to control, for the most part, what is said. The rule is in cross-examination that you only ask questions that have yes or no answers. You ask closed-ended, leading questions. You frame the entire question and the only answer is yes or no, right? And then you'll see lawyers say, no. The answer is yes or no. What is the answer to the question? That's because cross-examination is an art form. You ask closed-ended questions because you know what you're going to do if the answer is yes and what you're going to do if the answer is no. So that way you have a plan for how you're going to trap the person on the stand. So by the general strategy rules of cross-examination, it's not a good idea to ask questions that A, are not closed-ended, yes or no, or short answer, or B, that you don't know the answer to, especially when the answer could not be good for your client. So I think that was a little bit of a slip up by the lawyer here.
Now, have you ascertained any evidence that this shooting was pre-planned?
No,
Okay.
not at this time.
And would you agree that from what we've seen so far, from the evidence you've seen so far, the shooting was a reaction to what was on that cell phone in that moment? Is that accurate?
Objection, Your Honor. Also speculation outside of his scope of expertise.
Your Honor, I believe that if he has formed an opinion about the investigation up to this point, especially at a preliminary hearing, he can speculate on that, Judge.
Or sustained.
Sure. So, is there anything other than the content of the phone that this video will reveal to us about why this took place?
No.
Does it appear that this took place as a reaction to what was happening in the chambers at that point?
I can say it occurred after a phone call was made. I don't know what was said or nothing like that, but
Fair enough, and I'm not asking you the content of any of that, but at this point, is it your theory that whatever that content was in the discussion was the impetus of the shooting?
it could be, but I don't know that for a fact.
Okay. Do you have any evidence up until this point that you have developed that would demonstrate that it was not as a reaction to what was on the phone?
No.
None whatsoever?
No.
Okay.
Okay, so this is where the prosecution really messed up, because when the defense attorney asked, is there any evidence that you've been able to find that suggested this was pre-planned? He said no. Now, keep in mind, his answer to everything else is, well, it's too early, lots of information, blah, 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 blah. He didn't have enough sense to understand that this theory of motive was so important to the state's case, and he just Answer, no evidence of premeditation. No evidence that it was pre-planned. Prosecutor objects, but it's too late. And then after the prosecutor objects, he didn't stick with it. He didn't fight for the objection. He allowed the defense attorney to continue to dig until he finally got what he wanted. Again, no evidence whatsoever, none up to this point, that would demonstrate that this was anything other than a reaction to the phone. Again, he is successfully laying the foundation of in the moment, in the heat of the moment, heat of passion, second-degree murder or manslaughter defense to this homicide charge. And the prosecutor basically just sat there and let him do it.
Did you attempt to speak to Sheriff Steins at the Leslie County Jail after the incident?
No,
Did anyone from your agency attempt to interview him?
not to my knowledge, no.
And at that point, had he asserted his right to an attorney or anything?
No,
But nobody went back to try to talk to him or do an interview?
no.
Now, this is an interesting piece of testimony because it really exposes the sort of double standard in the criminal justice system. You can assert your rights to not talk without a lawyer, and they're going to hound you to death. And they'll break all the rules and just figure the judge will sort it out in the end. But they're dealing with another law enforcement officer who shot somebody on camera who happened to be another elected official. He didn't invoke his right to counsel, and they did not even attempt to go interview him. That's pretty strange, right? It means one of two things. It either means that they know that they believe that he was justified in shooting the judge, or they believe that it was such an open and closed slam dunk case that there wasn't any reason to get a statement from him. Or I guess it could mean a third thing, which is that the information that they would have gotten from him that might have made its way into the courtroom would have been so prejudicial to the victim, in this case, the judge, that they didn't want the answers. So I guess you guys can decide where you think that this situation lands on that sort of continuum, but there's only a few reasons why, because they would have hounded us to death. Had we done this, they would have wanted to know why. They would have, until we invoked our right to counsel, maybe a couple times, they would have sat there and interrogate us. Remember the guy in California who was accused of killing his father, who the police officer found in the middle of the interview that was still alive and still got the guy to confess to killing his dad, who the officer knew was not dead? So that's a good example of the double standard in the criminal justice system.
Okay. I think I have one other question. In addition to cell phones that we've discussed, the cell phone of Sheriff Steins and the cell phone that you found of Judge Mullins, were there additional phones that you were able to obtain?
There was one other phone that's currently being examined, and the basic reason it was seized was there was a text conversation between Sheriff Steins and some of his employees with the sheriff's office.
Okay, and that was an additional phone of Sheriff Steins.
It was a phone of, I guess she's the, I don't know what her title is, but she's employed. She's not sworn. She's employed by the Letcher County Sheriff's Office. And she voluntarily gave her phone to the person that interviewed her.
Okay, and just out of curiosity, could you explain why that was relevant or germane to your investigation?
I didn't conduct that interview, but it was, I guess it was regarding the dinner at Streetside and things that led up to the shooting. But I don't have those results either, so I don't know exactly what was said.
Correct me if I'm wrong. I thought when we discussed that earlier that you indicated there was no evidence that the conversations at the lunch.
I haven't seen those conversations yet. I've not received the downloads from the phone.
Right, but I asked you if you're aware of any information that could have been gleaned from witnesses at that meeting, and as I recall, you said no, but there is some information that something was discussed at this lunch. Is that correct?
I don't know what was discussed at lunch.
I understand, but you obtained this lady that we don't know her name, you obtained her phone in an effort or based on a belief that she would be able to demonstrate what was said at lunch. So you would agree with me, you believe that there is a witness or information that may have popped up at lunch?
There's a recorded interview with her in the case, and I'm yet to receive the downloads of the phone, so I don't know what they contain.
Okay, has that phone been sent to the
It is.
forensic examination as well?
Yes.
All right, thank you. Officer, that's all I have. Thank you.
So the attorney did a good job here because, again, he's calling him to question his credibility. This is the second time that he's caught him up in a trap of, well, you said one thing, but then, later down the line when I asked you this other question that was similar or had similar information, you said a different thing. And so that's the second time this guy has said, no, nothing happened, and, oh, yeah, something happened. And it's obvious that he intentionally dodged the first question and probably forgot about it by the time the second question got asked. And so, again, this investigator is either incompetent or intentionally holding back information. Either way, it doesn't look good for him. But the lawyer's done exactly what he should do, is score the point and then back off. You don't spike the ball in this situation. You score the point and you hand the ball to the ref and you walk over to your side of the field and you just take the points. That's how this game should be played, and he's doing a good job.
Redirect. Questions? Has Judge Mullins, he's sent to medical examiner's office for an autopsy.
He was.
Have you received that report yet?
No.
Have you had an informal conversation with him regarding his cause of death?
Yes.
And what was that?
Multiple gunshot wounds.
The video we showed earlier, that a true and accurate clip copy of what you received?
Yes.
Comes exhibit number 1, Your Honor.
Any objection?
Your Honor, I'd ask, of course, all we saw today was the clip, but I ask it be admitted in its entirety, Your Honor, as an exhibit.
You want to respond to that?
Good job. I don't think preliminary hearing is required for probable cause. This statute of probable cause, I think the entire clip is outside the purview of these proceedings today.
Yeah, I think if you want to see the whole video, you should have objected earlier. I'll admit the short clip. Yeah. I'll have the clerk enter that as exhibit number 1.
And Detective, is this an ongoing investigation?
Yes, it is.
And as this ongoing investigation proceeds, you will be also interviewing more people if necessary, submitting more evidence to the lab.
Yes.
That's all I have, Your Honor.
Recross.
All right. Any other witnesses for the Commonwealth?
No, further, Your Honor.
All right. You may step down. Any witnesses for the defendant? I'll find probable cause and bind this case over the grand jury. Anything else? Anything else before we adjourn court?
Yes, Your Honor, there's no, we're not allowed to sum up, Judge, what.
Oh, if you want to make an argument, sure. Yeah.
It sounds like I may change your mind, Judge.
It is a probable cause hearing, so but yes,
I understand.
take your best shot.
Thank you, Your Honor. Well, so, murder under our statute, as the court knows, and I'm not telling you anything you don't know, but if there is an issue as to extreme emotional disturbance, then there has to be some evidence that would rebut that. And specifically, when I asked the witness today if there was any evidence to rebut that this occurred as a direct result in the moment of this observation of the phone, they have none at this point. And I get it's just probable cause, but I think they've established probable cause for manslaughter first, but not murder. Because I've heard nothing that indicates that this is not, an example of an extreme emotional disturbance relative to the phone. At any rate, Judge, respectfully, I understand the court's previous ruling, but I did want to address that with you.
No, that's fine. Let the
Thank you, Your Honor.
Commonwealth respond.
Thank you, Your Honor. Extreme emotional disturbance is a defense. There's not been a defense presented here to this court today. The evidence presented to this court today is that the judge was intentionally shot and killed, multiple times by the sheriff, and there's probable cause to bind us to the grand jury murder charge.
Yeah, I agree. There's probable cause to proceed as murder.
Yes, sir.
All right.
Okay, so now you can see as this defense lawyer is making his argument against probable cause, and again, the judge has already announced that he's made his ruling, right? And the prosecutor did do a good job. The manslaughter and all of that heat of passion stuff is a defense to the premeditation part of the murder charge. And so it wouldn't be something that would be used to dispute probable cause. But the defense lawyer did a good job of putting it on the record that everything that's come out in this preliminary hearing has weighed more against the notion of premeditation than it has for the notion of premeditation. And so, just as I mentioned earlier, it's not about them trying to get him out of it. It's about them laying the foundation for this was a heat of the moment type thing. This is manslaughter or second-degree murder at best. It's not premeditated. And so now you can see why that was said in the way that it was said. The lawyer is doing what he's supposed to do in trying to establish this case more along the lines of not premeditated, more heat of the moment, second-degree murder, manslaughter. But I promised you I'd come back and talk about this. Here's the problem. I'm going to put some stills up here of the actual video. Remember when I told you that the shooting happened in sort of like layers or stages? Stage one was the sheriff standing up, firing the initial cluster of rounds at the judge, right? That might be able to be argued as heat of the moment, passion, whatever. When he moves around the edge of the table to reach down, point the gun again, he had time to make a different decision. And so when he reaches over the desk, he is not happy with his aim point. He's not happy with his sight picture. He doesn't feel confident in his ability to fire a kill shot. So he readjusts and fires a single round. That lets you know that he's not unloading the magazine into the judge. You know, he fired the initial cluster, boom, 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 boom. Then he moves around, and then he's waiting for that one shot that he's trying to make sure he kills him. Premeditation can be formed in an instant, in the blink of an eye. So that, to me, I think if I'm the state, I'm arguing that that is when the premeditation is formed. When he sees the judge fall, he had an opportunity to leave. He moves around the desk. He is not happy with his shot. He still had an opportunity to leave. No, he waits for a single shot that he can take that he believes is either a headshot or a heart shot or a kill shot. And then he fires. And then he's walking out of the room. Again, has the opportunity to leave. Again, has the opportunity to make a different decision. Turns back around, ducks under, and fires another 1 to 3 rounds into the judge to make sure that he kills him. And I think that's where the premeditation comes in, even if you can't establish that something in their prior relationship gave rise to this premeditation. So I think this is going to be a serious problem. And so it's really strange. This case could go, 3 different ways. He could spend the rest of his life in prison or get the death penalty on a full conviction for premeditated murder, or he could be completely acquitted, or he could end up getting manslaughter, all depending on how it shakes out. So it's going to be interesting to see what happens. In closing, jury nullification is a real thing. And I think that there is a possibility, there's a world where, depending on what comes out in this investigation, the sheriff could be acquitted of his charge. People in, I don't know what it's like where you live, but people in the South, it might surprise you to learn, believe that it's okay to take the life of somebody who is diddling kids. There's a lot of people on juries in the South who would be completely fine if it does come out that the judge has had an inappropriate or sexual relationship or a grooming relationship with this 16 or 17-year-old girl, that would be sympathetic to the sheriff for killing him over it. So there is a possibility, and you got to keep in mind, you have to have a unanimous jury in order to convict somebody of a homicide. And so there is a possibility where this could be an acquittal. You guys have seen the movie A Time to Kill. That happens. There was a guy in Texas who shot a guy. It was technically legally speaking, it was a homicide. But that guy had raped or done some sexually assaulted or sexually abused his young daughter, and he went and hunted him down and killed him, and the jury acquitted him of it. So it's possible. Jury nullification is real. Juries are composed of human beings who have moral compasses that are different than what the technicalities of the law say. And so, depending on what comes out in this investigation, it's possible that this thing could not be a slam dunk, which is why I said it's a little early to be so confident in your case. So it's either incompetence or overconfidence. Either way, it could potentially bite the state in the butt here. I'm going to be following this, and it's interesting to kind of flesh it out to see how this ends up turning out, because I think there's a whole lot more information out there that we don't know yet that is going to change the way the public looks at this case. I thought you might be interested in the technical legal aspects of what it takes to establish probable cause in a preliminary hearing setting, and sort of the scope of what gets presented and who gets to be in control of that and all of that stuff that nobody ever talks about. So hope you guys got something from it. I apologize for the length, but appreciate you checking it out. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel, leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.